Okay, we are now live and recorded.
Thank you. Welcome, everybody. Justin, would you please take attendance?
Sure. Bell,
Here.
Duran, Farwell, Jones, Lawrence,
Here.
Mayorga, Moab,
Here.
Macau, Pansky,
Here.
Rosenblatt, Schneider,
Here.
Selig. I will say his name again. Selig.
Here.
All right. Stallings. Judge Wang. And Chairman Lear. So we're
Here.
at 7. So we don't have a quorum yet, but once I see Mr. Farwell join and we can get a quorum, I'll bring that to your attention. But we can continue the discussion now outside of a quorum until we achieve one.
Okay, thank you.
Justin, will you please promote Drew Mixie? He's in at the attendee list.
Oh, sure. Okay, he has been promoted. We can take public comment now. So if there is anyone in attendance that wishes to give public comment, if they could raise their hand. And I only see one member of the public that is actually State Bar staff. So I think we can proceed on with the agenda.
Terrific. And with respect to the agenda, my understanding is that we have some presentations. And Justin, which is the first presentation we have this morning?
We have a presentation on diversion in the criminal context, but I will first begin the presentation with going over the kind of the timeline and setting the agenda for the meeting. So if Melanie, if you could share, or Melanie, Lisa, if you could share. Thank you and welcome. So I wanted to provide some context to the subcommittee as to where we are headed in terms of the whole ad hoc commission in general. This is a brief timeline of what to expect going forward. There has been a scheduled meeting in September for the full ad hoc commission meeting. There's a fairness subcommittee that's also taking place this month. And at that full ad hoc commission meeting, each subcommittee is going to share their findings with the other subcommittee. And there's going to be a finalization of working groups. There have been 3 working groups created so far, and I anticipate another couple of working groups to really go into the recommendations and get into the details to develop these recommendations. And so towards the end of the year of 21 and the first month of 22, we anticipate these working groups meeting frequently to develop these recommendations and eventually have them come back to the full ad hoc commission. It'll probably take a couple meetings to vet all of these different recommendations, and they will bring it to the full ad hoc commission meeting in February, March, and April of 22. Once we have those recommendations, there will be a report that will be presented to the full ad hoc commission that will be adopted in May or early June of 22, because the final report is due to the Board of Trustees by June 30th of 2022. And so I just wanted to provide this overview of that the subcommittees have done a lot of their work, and then breaking these recommendations or areas of focus into working groups has worked best in other entities that we've done this with. And so that's where the focus is going to be in the working groups to get into the details. And then the full ad hoc commission, even if you aren't in a working group, you will get a full representation and be able to adopt those recommendations. So that's just a brief overview. If we can go to the next slide. On the agenda for today's meeting is a discussion on diversion, a discussion on metrics, and then the final discussion is where we bring back all the topics to make sure that we're all on the same page. And if there are areas of focus that we haven't identified yet, we do identify them before we go to the September 2021 full ad hoc commission meeting. So with that, we will start on diversion. The next slide. So this is a brief overview of diversion in the criminal context. After I give this presentation on this, then we will talk about what the state bar is currently doing as it relates to diversion. It's not exactly true diversion, although the agreements in lieu of discipline that that Drew is going to talk about and our alternative discipline program are similar to diversion, but they're not exactly diversion. So if you could go to the next slide, Lisa. So diversion in a criminal context, there are two main types of the diversion. The pretrial diversion is the suspect suspends the criminal proceedings and that there is no plea entered. And there are defined conditions that are met or the criminal proceedings do resume. And what the main component of this is that if someone successfully completes this pretrial diversion, the charges are dismissed. So the charges are as if they didn't happen and the person can claim that they were not charged or arrested for that offense. The post-trial diversion is a guilty plea is entered. The judgment is deferred. So this is kind of like it's already gone through the process and it is deferred. And it's the same component that if they are successfully complete these terms and conditions, that the charges are dismissed. But if they are failed to complete these conditions, then it results in the sentencing that was deferred at one point in time. And this is similar to kind of how our ADP works, is that there are stipulations, but Drew will give you more specifics on that shortly. If we can go to the next slide. A type of diversion is AB 3234 is a court-initiated misdemeanor diversion program, and this was passed last year in the California state legislature, and it provides authority for Superior Court judges to offer a pretrial diversion. And the big difference on this is that it can be done over the objection of the prosecution. And a lot of these misdemeanors that this program entails, it opens it up to almost all misdemeanors, except for those that are, domestic violence related or would require the person to register as a sex offender. So there are specific cutouts, but it does open it up for a majority of the misdemeanors. If the defendant completes the terms and conditions, the case is dismissed, like we talked about before, and the arrest record is sealed, and the defendant can answer that he or she was not arrested or charged with a deferred offense, with those minor exceptions. And those minor exceptions have to do with, an application to become a peace officer or certain other applications that have exemptions. But this is something that was passed last year and has been implemented by a lot of the different counties in the state of California. The next slide, please. And then I just wanted to give a brief overview on the collaborative justice courts. So these are the different types of courts that occur in counties throughout California. There are drug courts for those that have substance abuse or mental health issues. There are DUI courts that are numerous throughout the counties. There are mental health courts. So if you have a mental health issue and you can find a nexus between the offense and your mental health issue, you can qualify for that court. There's community and homeless courts, and these courts have become more frequent because of the homelessness population increase, and they are specific to do with misdemeanor offenses that have to do with homelessness. Trespassing, those kind of things. And then veterans treatments courts. These are courts that have to do specifically with veterans issues. If you're dealing with PTSD or other mental health issues, they're specifically been created to address issues with veterans. And so these are just some of the different courts that are in the criminal system, and they all operate with the same tenet that if you successfully complete the terms and conditions, the cases are dismissed. And so that was just to provide a brief overview. And now we will go and focus on what the State Bar currently does as it relates to diversion programs. And with that, I'm going to turn it over to Drew. And I promoted you, right, Drew? Drew Macy is with our Office of Chief Trial Counsel, and I'll let him introduce himself.
Great, thank you very much. Good morning, everybody. My name is Drew Massey, and I'm a supervising attorney with the Office of Chief Trial Counsel. And I was asked to do a couple of presentations today. The first on agreements in lieu of discipline. Can we move to the next slide? Okay. Just as the State Bar is empowered to recommend discipline for various acts of misconduct, it can also take actions that are short of discipline. And some very common examples that OCTC, the Office of Chief Trial Counsel, uses are directional letters, resource letters, and warning letters. A directional letter is where we ask the attorney to take some action. So, for example, maybe we receive a complaint that the attorney is not communicating with their client. So we might send a letter saying, hey, we got this complaint, please contact your client. But otherwise, that would be the end of the case. Resource letters occur where respondent's conduct may be concerning, but it doesn't violate a particular rule. And so instead, what we do is we send them a letter with various resources, for example, the ethics hotline, or other sources they can use to sort of better guide themselves in the future. And then finally, a warning letter occurs where we have substantial evidence of a violation, but typically the violation is very minor. These are pretty common when we see advertising violations. Many of them get resolved with warning letters. But the warning letter, the purpose there is that it puts them on notice of the misconduct with the goal that once notified that what they're doing is not appropriate, they will revise their behavior and then we won't have to deal with them going forward. Can you go to the next slide, please? Okay, so the most serious non-disciplinary action that the State Bar can take typically is the agreement in lieu of discipline. Usually with the letters, they're sent out and then the case is closed. Rarely there is some action, they get conditioned on some action by the attorney, but in most cases, the case is resolved with the sending of the letter. By contrast, an ALD requires the attorney to engage in specific acts over a period of time. And not only are they required to do that by the terms of their agreement, but there's also Business and Professions Code, section 6068L. That is a lowercase l and not a capital I. But 6068L requires compliance among the oaths and duties of an attorney. Can we go to the next slide, please? So when is an ALD appropriate? When do we use these? So because it is non-disciplinary, it would not be appropriate for any misconduct that would otherwise result in discipline, right? If discipline is warranted, then we're past the ALD stage. So typically ALDs are reserved for very minor misconduct. To that end, anything, if we get a case that involves moral turpitude, dishonesty, or corruption, that probably is not going to be appropriate for an ALD. Because we're looking at minor misconduct, it's also typically misconduct that didn't result in harm to a client or the administration of justice, or where there's substantial mitigation that outweighs any minor aggravation. So some examples might be a case that, all things being equal, maybe would have resulted in a private reproval, which is sort of the lowest level of discipline. But maybe the attorney has a lot of mitigation. They've been in practice for many, many years. They have, they've been pillars of the community, that sort of thing. And so a downward deviation is warranted. Since we're already at the lowest level of discipline, we can't really deviate downward to less discipline. And so we get to an ALD. Another example might be misconduct that was influenced by a particular short-term event. Maybe the attorney had gone through a divorce or a significant illness or even the death of a loved one. And so the idea is, well, this misconduct, this minor misconduct was because of this unique event. And so we want to maybe we want a little bit of monitoring over the course of time to make sure that it is an aberrational, unique event, but that might be another instance in which we went forward with an ALD. I could go to the next slide, please. Okay, so an ALD is an agreement between the attorney and the Office of Chief Trial Counsel. Because it's non-disciplinary, it generally doesn't require review or approval by the State Bar Court. And as part of the ALD process, the attorney must stipulate to the misconduct. So if the attorney doesn't want to admit that they did whatever they did, and again, this tends to be used for minor misconduct, but if they don't want to admit to it, or if they're seeking to avoid culpability or responsibility for their actions, then an ALD is not really appropriate. The part of the purpose is for the attorney to agree that what they did was wrong, and then we can sort of move on from there. Now, it also includes part of the agreement is identifying which particular rules of professional conduct or provisions of the Business and Professions Code that were violated. So we're all on the same page as part of the stipulation. And then finally, the agreement also requires the attorney to take specific actions for a particular term. Typically, that's 1 year that they have to take those actions. Can we go to the next slide, please? All right, so some of the actions that an attorney takes, many of them are often borrowed from some of the more common disciplinary probation requirements. For instance, it's often a requirement that the attorney attend State Bar Ethics School, and in certain circumstances, the Client Trust Accounting School. The goal here is to help them refamiliarize themselves with the requirements of the profession. Often, the attorney might be asked to complete quarterly reports. So once each quarter, the requirement is the attorney reflects on their past conduct, and they send in a document certifying that they have not violated any rules of professional conduct or business professions codes during that past quarter. And it's a really simple thing to do. It's basically a one-page document that they sign and send in. But the value there is that it does cause them to reflect on their past actions and to make sure that what they're doing is in line with the requirements of the profession. And to that same end, another common requirement is that they must review the rules of professional conduct and particular business and profession code sections that are relevant to them. These requirements are designed to help the attorney sort of avoid misconduct in the future, to refamiliarize themselves with what is required of the profession, and they're not intended to be overly burdensome. Can we move to the next slide, please? Okay, so what does an attorney get out of this? Why would they want to go into an ALD? Well, first, the ALD is non-disciplinary. So if they're later asked if they've ever received professional discipline, they can answer no, they haven't. It is not discipline. Second, the matter is kept confidential. So this agreement in lieu of discipline would not be posted on the State Bar website. It would not be disclosed to the public. It is completely confidential. Third, because it is non-discipline, the attorney will not incur any disciplinary costs or disciplinary sanctions. So there's a financial motivation there as well. And finally, it completely resolves the underlying disciplinary complaint. Part of the agreement is that if the attorney abides by the obligations, if the complaint is fully resolved, it never proceeds to prosecution. You can think of it as, I mean, we haven't gotten to a court case in this typically with an ALD, but it would serve the same function as like a dismissal with prejudice. Okay, can we move to the next slide, please? All right, so what if an attorney doesn't abide by the ALD? I should start by saying that that sort of situation is extremely rare. You know, ALDs in general are not a super common method for resolving complaints. It's fairly rare for a situation to be so serious that a warning letter is not insufficient, but also at the same time, so minor that a private reproval is too harsh. So ALDs sort of fall into this middle category that's definitely used by our office, and we have ALDs, but I would imagine they represent a pretty distinct minority of cases. But with that in mind, because ALDs tend to be used for minor misconduct and for attorneys that appreciate the wrongfulness of their actions and are willing to engage in order, having to go any further with the state bar in the future, typically attorneys with ALDs tend to be pretty motivated to comply and put the issues behind them. So violations of an ALD are very uncommon. That said, if an attorney does breach their ALD, the state bar has two actions it can take. First, it can reopen the closed complaint and prosecute it, right? The reason it was closed is because of the ALD, and if the ALD is not fulfilled, then we can go forward with it. And second, as I mentioned earlier, failing to keep the ALD is a violation of Business and Professions Code 606AL, and therefore there's actually a second charge for violating that section that could be used for discipline on its own. Can we go to the next slide, please? Okay, so that's sort of the overview of ALDs and what they're used for and how they work. Are there any questions or anything I can clear up?
Thank you for that, Drew. Could you walk us through a little bit the process between or how your office determines whether to offer an ALD, a warning letter, or private approval? And for those of you that are not necessarily really familiar with those terms, the ALD falls between the private approval, which out of those three categories would be actual discipline, and the highest out of those three. And then the warning letter is lower than an ALD and can be effectively used. And I can tell you, after very, very many years of doing this, I don't see much of a distinction between a warning letter and an ALD for my clients' purposes, because they are both non-discipline. So if you could just walk us through that, that'd be helpful. Thank you.
Sure. So in some sense, I think you're right that those three levels are very near each other, right? They all involve relatively minor misconduct. They all involve issues where we don't see a lot of harm to the public or to a client. So you will see, I think it really comes down to the factors of an individual case about where it sort of lands on that scope. The two instances that I mentioned in the presentation, I think are the most common that sort of jump to my mind. And one is somebody that would normally be receiving discipline at the low end at a private approval. But like I said, maybe they've got a lot of mitigation because they've been in practice for many years without prior disciplines. Maybe they have a lot of good character evidence. And so you look at that and think, all right, if normally with that much mitigation, we would go lower on the discipline spectrum, but we can't go any lower because we're already at private approval. So we drop down to an ALD. And similarly, you might have somebody that has engaged in minor misconduct that because they, maybe they were in the hospital for a brief period of time, and they say, all right, now that's, that situation's fixed, so I'm not going to commit any more misconduct in the future. That might also be a situation where we'd say, well, this might be a warning letter situation, but because of this may be an ongoing issue, it warrants having a 1-year period where they're checking in on a quarterly basis to say, all right, yes, I'm still doing good. I've reviewed the rules, everything's fine. And that might be appropriate in those instances as well. Like I mentioned, ALDs, they sort of occupy this middle ground between the private approval and the warning letter, and there just aren't that many cases that fall into that. Okay, thank you. And I'm going to call on Linda now. Linda has experience with a different type of professional licensing that I also engage in on the defensive side, on the defense side. And Linda, could you walk through a little bit how this works for doctors and the DRE licensees and the Department of Insurance licensees in terms of the levels of discipline that are offered? And in particular, it's been, let's call it frustrating for me on behalf of my clients that there is not an ALD type of resolution that's offered in that context. Could you talk about your experience with that and maybe touch upon why they don't have the extra levels that the bar has? Because I think with the bar, they do have many options for non-discipline that the other licensees don't. And I'm just curious as to what the rationale is in the other form.
Well, first of all, I haven't represented the agencies that you mentioned, so I don't have any direct knowledge of those particular agencies. They are not part of the collection of clients represented by the licensing section. In the licensing section, we represented about 30 different agencies within the Department of Consumer Affairs, not including the medical board. The Department of Real Estate was part of DCA for a while, and then it's reverted back to its own department again, but we never represented them while they were in DCA either. But to answer your question from the perspective that of the agencies that I did represent, I can't think of any that had an agreement of this sort not to engage in disciplinary proceedings if discipline was appropriate. There were agencies that had warning letters and that sort of thing. So within the prosecutorial discretion of the executive officer of the agency, they may be issued a warning letter instead of an accusation being filed against the respondent. That certainly is a possibility and would be in just about any of the agencies we represented. The only one I can think of that had a private reproval, in other words, discipline where it was not a public record, was the Office of Real Estate Appraisers. They had such an animal, but I don't think anybody else did. The only other one I can think of where there was any kind of a private discipline is the Commission on Teacher Credentialing. They had such a thing. But those are the only two that I can think of that had even a private level of discipline. Everybody else is throughout the Department of Consumer Affairs. Public disclosure is of paramount importance for discipline so that the public is aware of what's going on with their licensees, both for knowledge of the licensees and also for the integrity of the system. So I hope that helps you a little bit.
Little bit, and thanks for that. So let's go to the Board of Nursing, which I think that you probably did deal with.
Yes.
And I deal and a good friend of several people on this committee, Kim Kostrelevich, is now a prosecutor there. But if you could walk us through maybe the rationale, if you know it, as to why the Board of Nursing does not have the equivalent of an ALD. I think it would be informative in the context of this discussion.
Well, you know, that's interesting the way you put the question. What is their reasoning for not having one? I guess I would flip it and say, what is the reason for having one? You know, none of these agencies have such a thing. So why they don't, I can't tell you why they don't. Other than the reasons I mentioned, that the Department of Consumer Affairs in general feels that public disclosure is a very important part of discipline. So it's the perspective that, you know, I've always had, and it surprised me a bit to learn that the State Bar has these types of agreements and that are, you know, not disclosed to the public, and the private reproval type of discipline that, again, is not disclosed to the public. So I can't tell you why they don't, other than the perspective that they think that it's very important to have things disclosed to the public, to be very transparent.
Okay, all right, thank you. And it's not, nobody is going to be shocked that my view, and probably Ellen's view, is that ALDs are the best things ever. And they are, from the defense perspective, our view generally would be that everybody is getting what they, on a low level misconduct, that the ALD accomplishes a lot, because one, it's a severe hand slap to the respondent. Two, there are conditions attached to it, so that if hypothetically there's an issue with, let's say, competence, then there's a way to address that by requiring in the ALD as a condition that the particular respondent go take some MCLE courses on that particular substantive area. And so it just works for everybody because this is not going to happen again. And Drew can speak to what I'm pretty sure is the office policy, which is if they are gracious enough to enter into an ALD with a respondent, then OCTC's position would be, if you come back around with the same misconduct within a relatively short period of time, then we will hammer you. And that's the discussion I have with every client in that context, which is, you got lucky here, you got an ALD, but if you make that same mistake again, that's in the file and you will get hammered. So, and we're trying to scare them straight. So Drew, could you speak to, well, actually,
Hey, Chair, I just wanted to make sure, can you see that Ellen's hand is up and Melanie's hand is up? They've had their hands raised for a while. So
Thank you very much. I did not see that. So whose hand was up first?
Ellen, it looks like her hand was up first and then Melanie.
Thank you.
Thank you so much. I just wanted to make one point and then respond for a moment to Linda Schneider's comments. There's also another degree of discipline that's lower than a private reproval, which was an admonition. And back when I was at the State Bar, admonitions were used frequently. They seem to have fallen out of favor, and I'm not sure when that happened, but I just want to point out that there is another tool in Chief Trial Counsel's toolbox. And if I recall correctly, it's actually authorized by rule, I think it's 5.126 of the rules of procedure. So, when we're talking about what appropriate dispositions there are, I'd like to also throw an admonition into the mix. And then, Linda, I wanted to point out that this issue of private or confidential private reprovals and other confidential dispositions has been studied and analyzed many times over the years. And I happened to pull up a memo that the author of which was former State Bar Court Judge Ellen Peck. It's dated October 22nd, 2014, from the Working Group 2 on what was then a Discipline Standards Task Force. So I'm thinking that maybe it would be good if staff could circulate that memo to our committee or our subcommittee, because it explains the reasons why we do have private dispositions. I think it would be helpful.
Thank you. And Justin, I'm on an iPad, so the hand raising is not appearing on my screen. So if you could jump in when you see hands raised and just give me direction. But with that, we'll go to Melanie.
Thank you. I really just wanted to respond to your query, Ed, about the use of warning letters versus ALDs in the office. And I think one of the things that we would be thinking about to resolve a case by an ALD rather than a warning letter is that an ALD gives us more of an opportunity to monitor the person. Warning letters, I mean, we can do that. They're conditional, but they're for relatively short periods of time, usually. For example, if they were going to be conditioned upon ethics school, and we can add significantly more conditions with an ALD. The other benefit for us is that it requires the respondent to stipulate to facts and conclusions of law, which are binding on the respondent, if in fact they violate the ALD, and then we're going to move forward for prosecution. So that's a benefit versus a warning letter. I will say that ALDs are a lot of work for our office, besides the fact of putting them together, which in some instances are more paperwork than a regular stipulation, frankly, and certainly more paperwork than a warning letter. We have to actually monitor it. We have to assign staff to monitor it. It's not at some point in time, it was monitored by the Office of Probation, but now our office has to monitor it. So we designate resources for that as well. So that's all. Thank you.
Thank you. Justin, any other hands up?
There are no other hands up.
Okay. Drew, do you have any more comments?
Yeah, I'm just responding earlier to what you said about the office policy for a violation of or somebody who comes back after having an ALD. I don't think there is an office policy to hammer anyone, but certainly if they have an ALD for the same misconduct and that didn't work, right, and they're on notice that what they're doing is misconduct, that would be taken into account in our decisions going forward.
I have a question. Sorry.
Yeah.
Yeah,
Yeah.
I just want to make sure I understand how that particular point that you just made, Drew, how that differs from a traditional criminal diversion context. So like if someone participates in diversion, then later they come back, there's a new offense. Is the fact that they were once in a diversion program or got diverted, is that taken into account in the subsequent criminal prosecution?
Actually, I can jump in here since I have some experience in this area, and that is yes, it is considered, and generally it's a disqualifying factor within a certain time frame for subsequent diversion, at least in the sense of optional DA diversion, statutory diversion, drug diversion. I don't know whether it is a disqualifying factor or a consideration, but on the DA diversion type of programs that DAs set up, it generally is a disqualifying factor for a period of, for example, 5 years.
Okay, but is it counted? It's not counted as a prior or anything like that.
No, because it's just if they have been through the program before, they would not. The office wouldn't generally grant it again. It's not material whether they failed that diversion or not in that circumstance.
Okay.
If that answers your question.
Yeah, I'm just trying to understand like how similar or different are ALDs to that paradigm.
I have a question, and this is either a Steve, Melanie, or Drew question directed to, and I asked this of a judge several years ago, and he didn't know. And the question is, if a matter proceeds to trial and the ultimate result is an admonition, does that go on the membership record?
I do not know the answer to that question.
I think it's like a unicorn. I don't think it happens that often, but nobody, yeah, we don't know. Ellen, do you know?
It shouldn't, just like a private approval shouldn't go on. I mean, it will be on the internal records of the state bar, but it shouldn't be. If you look at the state bar court reporter, you'll notice that there are a number of cases, quite a number, which is identified by in re respondent A, B, C, so forth. And that's because in those kinds of situations, there's no publicity given to the name. So, I mean, I can stand corrected, but that's my understanding.
Okay, and I apologize for getting into the weeds. That's not a very interesting question, but everybody should know that as far as I know, the judges cannot award an agreement in lieu of discipline. And so what they would do in the context where they think a private approval is too high and a dismissal is too low, is they would, the midpoint would be an admonition. That's why I asked that question. Okay, so I'm done with that. Does anybody else have any questions or comments?
Doesn't look like there's any hands raised, so we can move on to Drew's next presentation.
Thank you.
Okay, good morning again. I'm sorry you have to hear from me 2 times. Hopefully it won't be too painful. But I've also been asked to talk about the alternative discipline program and how that works in the state bar. Can we go to the next slide, please? So our system of ADP is not the same as diversionary criminal court, but it does sort of serve an analogous role, I would say. The idea is that we recognize that some professional misconduct stems from either mental illness or substance abuse. In those instances, the thought is that if we can assist the attorney to remediate that underlying issue, then those issues will not be present to cause future misconduct. The attorney will be less likely to commit misconduct, and ultimately that protects the public and fulfills the mission of the disciplinary system. The goal of ADP is to assist attorneys with those issues. And although misconduct has occurred, and ultimately that means discipline is likely, it also means that we can give the attorney time to show that the underlying substance abuse or mental health issue has been addressed, and that they have, recovered from it or rehabilitated themselves. Can we go to the next slide, please? Okay, so with those sort of goals in mind, how does ADP actually work in the state bar court system? Generally, it starts with a request from the respondent, from the attorney. After the case has been filed, the rules actually say either party can make a request for referral to ADP proceedings. Although either party can, the Office of Chief Trial Counsel rarely does. And to my mind, it's really not appropriate for us in most instances to say that respondent has a mental health or substance abuse issue, especially if the respondent disagrees. And even if we were right, there does exist such an issue and the respondent is in denial. If he's not willing to admit it and engage with it, then he's not likely to be successful in ADP anyway. That said, OCTC rarely opposes a request for ADP. There is a time limit. It has to be done at least 45 days before trial, so it can't be used as sort of a last-minute delay tactic on the eve of hearing. But otherwise, OCTC generally does not object to the referral. Once referred, the matter is heard by a separate judge, which is called the program judge. All ADP hearings are confidential and closed to the public. And the reason is that hopefully allows the parties to discuss sensitive information related to mental health or substance abuse without fear of, personal information getting out. And if it turns out that ADP is not appropriate, the matter would be returned to the original judge who has learned none of that stuff. And so he would be able to, or she would be able to adjudicate the matter without reference to anything that occurred in ADP. If we go to the next slide, please. Okay, so to enter ADP, there are three main requirements. First, the respondent must be accepted into the Lawyers Assistance Program, or LAP. LAP is not connected with the court. It's not part of the state bar court, and it maintains their own rules for admission, and they create their own treatment plans. Sometimes getting into LAP can actually take a few months as they evaluate and develop a plan for the individual. But if LAP decides they can't assist with a particular issue, or they otherwise don't accept the attorney, then ADP is off the table. The matter gets returned for standard disciplinary proceedings. So LAP is an absolute requirement. The second requirement is that there must be evidence that the attorney's substance abuse or mental health issue has causally contributed to the misconduct. Sometimes this is very obvious from the misconduct. Maybe the disciplinary matter stems from a criminal conviction for drunk driving. The substance abuse issue there might be supported simply by a declaration from the attorney. Another common issue that we see in moving into ADP proceedings is an attorney who abandons one or more clients because they're suffering from depression, where they have trouble even getting out of bed. A doctor's note might be all that is necessary there. There may be other cases with sort of less obvious nexi that might require more evidence, but generally it's not a huge burden to show that the misconduct was causally connected to a problem like that. And in general, if the causal nexus seems reasonable, OCTC accepts it. The rules do allow OCTC to hire its own independent expert and demonstrate that the misconduct was not caused by the depression or whatever malady, and thereby return the matter to standard proceedings. But that's exceptionally rare, and I can't think off the top of my head of any incident where that has occurred. So with the nexus established, the final requirement is that the parties have to enter into a stipulation regarding the misconduct. The stipulation will cover all the relevant facts, as well as the conclusions of law, which provisions have been violated. And there are, I think, two main reasons for this requirement. I think one, it shows that the attorney is taking that first step to admit the misconduct and seek help, right? And that's part of what we want to see in the ADP process. And two, the ADP proceeding isn't really equipped to engage any kind of fact-finding trial. So instead, the parties are required to stipulate so that the proceeding can continue on that stipulated record. If the parties aren't willing to do that, then they have to go to where the fact-finding trial can occur, and that's standard proceedings. Next slide, please. All right. Once those three prerequisites are met, the attorney is basically eligible for the ADP process. The only question that sort of remains is what the level of discipline should be. Now, ADP lasts between 18 months and 3 years generally. And during that time, the attorney attends LAT meetings, often they're randomly drug tested, and they have to comply with other requirements that might be set by LAP or the ADP process. Assuming that attorney does well over that time period and now shows for an extended time that they've gotten their issue under control, they are now less likely to commit misconduct, and therefore they should receive a lower level of discipline than they otherwise would. So that's what we sometimes call the low discipline. By contrast, an attorney might enter into ADP and nevertheless continue to take the substance or avoid LAT meetings or otherwise fail to avoid the obligations. In that case, ADP could be terminated. There, the attorney's seeming unwillingness or inability to get their issue under control provides increased concern that it will lead to further misconduct, and therefore a greater level of discipline might be warranted. That's often called the high. To reflect this, the court sets what we sort of generally term the high-low. Typically, parties will be asked to brief the issue, and then the court looks at the stipulated facts, looks at the parties' arguments, and then sort of sets it. So just as sort of a general example, maybe if the case had gone to standard proceedings, the misconduct would have resulted in a 30-day actual suspension. That would have been the appropriate resolution. So instead, when we look at ADP, the judge might say, all right, if you successfully complete ADP, you get everything under control, and we're less concerned about future misconduct, you will get a stayed suspension, so no actual suspension time. But if you don't complete ADP and you get terminated because you continue to engage in bad conduct, then you'll actually get a 60-day period of actual suspension. So you get more suspension than you otherwise would had you gone through standard proceedings. Finally, once the judge sets that high-low, it basically drops down and the attorney gets the final choice. He sees the contract, he knows what the benefits and the consequences are, and he can either accept entry into ADP at that time, including complying with all terms and LAP and everything, and then he gets the guarantee of the high or low discipline based on his performance. Or if he doesn't like his options at that point, the attorney can refuse and just go back to standard proceedings. And the important thing to know is that if he does engage or she does engage in that option, the stipulation would be rejected and non-binding on the parties. So even though everyone has engaged in a stipulation, that wouldn't be binding if the case goes back to standard proceedings. Next slide, please. Okay, so once the person gets into ADP, the judge then sets regular hearings on the matter. Typically, they begin monthly or every other month. Then, if the attorney continues to demonstrate success, they often move to quarterly meetings, but the timing is largely at the discretion of the judge. Prior to each hearing, LAP will prepare a brief report indicating whether the attorney has complied with all of their obligations. And if not, it will specify which obligations are missed. And the important thing here is that the LAP report is it's a one-page document that basically says they either met it or they didn't meet it, and here's what they missed. But it doesn't go into their treatment. It doesn't have any phraseology they may have used during LAP meetings. All of that is very confidential and is not shared with our office. Now, in the majority of cases, attorneys in ADP take their obligations seriously. LAP reports routinely show compliance, and the hearings become mostly a sort of a check-in. They tend to be relatively brief. While ADP is intended to be a 3-year process, if the attorney is making excellent progress, they can move to graduate from ADP as early as the 18-month mark. Now, it does happen, it's a little less common, but it does happen that an attorney starts to receive non-compliant LAP reports. These non-compliance issues then get addressed at the hearing. And if there is serious non-compliance, such as drug tests that find a prohibited substance, or repeated issues, or not attending LAP meetings, things like that, it starts to look like the attorney is not taking the process seriously. In those instances, a court can terminate ADP and then impose the high or recommend the high discipline. But overall, ADP is an excellent way to address misconduct that occurs not from intentional or venal acts, but that follow from the poor judgment that comes from substance abuse or mental health issues. And if those issues can be controlled, the misconduct is less likely to recur. And ADP is a great way to help the attorney not only overcome those issues, but also to protect their license and livelihood as they do so. Next slide, please. Okay, as a last item, ADP isn't always appropriate. There are a few categories of cases that are not allowed. The more common ones here, I think there's 5 total, but these are the most common. One is where even with the additional mitigation of getting their issue under control, the low discipline is still disbarment. So even if they succeed, their misconduct was just so heinous, or they've got such a track record of prior records that it's going to be disbarment no matter what. In which case, there's really no reason to go through the ADP process. We should just move forward. Another is where the misconduct involved moral turpitude affecting a client or the administration of justice. Moral turpitude, like especially things like theft, dishonesty, they typically mean that the misconduct was knowing or willful in a way that takes it beyond the side effects of substance abuse or mental illness. And another disqualifier is where the attorney has been through ADP before. And that's true whether they were successful or not in the past. If the purpose of ADP was to get this issue under control and then moving forward, it wouldn't be a factor. Obviously, even if they kept it together for 3 years in the past, but they're right back at it, it's not clear that ADP is going to be successful this time if it wasn't last time. So ADP is not available more than once. And next slide, please. All right, any questions?
Thank you, Drew. Can you turn back to your last slide, please? The one before that. This one. Okay, and I'd really like everyone to chime in a little bit on this one because I think the talking points here are really important. And the point is, and I'm going to start with this by saying that I applaud the bar for initiating the ADP program many years ago. It might be 10 or 15 years at this point. And I think it was appropriate insofar as recognizing that there are mental health challenges and drug and alcohol addiction issues that could take somebody who's otherwise ethical and cause them to fall off the path. And so again, big plaudits for that. Terrific. My question to everybody and observation, I think generally. One, I think ADP works, and there are clearly some exceptions to that, but I think it works. And two, I've always questioned these carve-outs. Maybe I don't question as much the third one. Attorney has been through ADP before. Okay, let's say I concede on that one. But in particular, the second one is frustrating to me because I don't think that just because the state bar charges moral turpitude that a respondent should be disqualified. And I'll give you a quick anecdote and then I'll pass the microphone. I had a case within the last 2 years where the client, we were trying to get into the ADP program. You don't get in just by asking. You have to actually go through some hoops. And there, the judge ultimately found that moral turpitude was a disqualifying factor and denied my client from being an ADP. And he was somebody that I thought he had the mental health challenges. I think he was really deserving of being in there. And so it was frustrating. But what was particularly frustrating in that case is once we went back to the regular track, I negotiated away the moral turpitude in the final stipulation. So we had a situation where the bar ended up not insisting on moral turpitude in the final resolution, and yet the moral turpitude charge, unproven, was used to keep him out of ADP. So I found that beyond frustrating, and I expressed my frustration and agitation to the judge as well. And I had asked for a mini hearing just on the moral turpitude issue, because I didn't think the bar could prove it, denied, on and on. But so I found that frustrating, and because again, in the totality of at least that circumstance, my client really needed ADP, and he had been in LAP for 3 years and was really benefiting from it. And I thought that ADP was a nice path. So with that, and I see that part of what we can do out of this group and out of our committee or commission is to take advantage of opportunities for lawyers to not be disciplined or to have less discipline. And ADP is a really good opportunity for that. So that's where the carve out, to wit, 1 and 2 on the bullet points, would diminish the number of respondents who could be in ADP. All right, Ellen, comments.
Thank you. I want to build on the point you just made. You know, actually, it's been 20 years since the legislature passed BNP Code Section 6231, you know, which is in its title is referred to as a diversion program. And the legislative intent behind it was to provide an opportunity for lawyers, not just with drug or alcohol problems, but also with mental health issues, to be treated and to get credit for the fact that, you know, similar to the criminal diversion program, you know, if you're willing to be treated, if you go through the steps, and well, onerous is not the right word, but they're stringent. For a lot of lawyers in ADP, they are not only going to monthly meetings, they're also going to separate 12-step meetings. They're having random drug and alcohol testing. They may be required to get other kinds of medical care. In my practice, I found that a lot of, and this is actually supported by statistics, depression in the legal profession is extremely high. And a lot of lawyers go through burnout. And so a lot of their the problems that end up with state bar complaints are things like failure to communicate or missed court appearances, things that are directly related to the fact that they are depressed and unable to function. So I think the legislature was very wise in adopting a program to permit these lawyers to be treated, because that's the public protection that we're looking for. The goal is not to give somebody a reproval or a 3-month suspension, then they go right back into practice and their underlying problem isn't resolved. I think actually that ADP is underused, and I think it should be used more frequently. And to that end, I also object to the requirement that the respondent be necessarily willing to stipulate to whatever the state bar prosecutor proposes, because without a stipulation, the respondent cannot be an ADP. And so when the prosecutor says it's moral turpitude, if the respondent stipulates to moral turpitude, that's a disqualifier to be admitted into ADP or to stay in ADP. We need to change that. And that's just not, it's not right, and it's not fair for the reason that Ed has explained. And his is not the only example of a case where the ultimate disposition did not involve moral turpitude. There was no such finding, and yet the respondent was prohibited from participating in ADP. So I think a recommendation needs to be made to change at least that one current rule.
Thank you. Linda, then Melanie.
I have a question about the process, and that is where this fits. Where does ADP fit in the process? In other words, has a complaint or charges already been filed against the attorney? I see Drew nodding his head yes.
Yes, this is
So
after charges have been filed.
Okay, and so it's already a matter of public record that the attorney is discipline is being sought against the attorney. Is that correct? That's a public record?
Yes, that is correct.
Okay. And then my other question kind of goes to what Ellen was talking about and the stipulation, and I wasn't quite clear what happens with the stipulation. The attorney and the Office of Chief Trial Counsel, I take it, enter into the stipulation, and the judge sets a high-low on it, is kind of what I got. And then what happens with the stipulation if the attorney is unsuccessful in completing the ADP? That's what I was not.
So once they're in ADP, whether they're successful or not, the stipulation sort of stands as it is. Nothing different happens to the stipulation. The only time something happens different is if the high-low is set and the attorney decides he doesn't want to be an ADP, and he says, you know, this high-low is not good for me. I think I have a better shot at standard proceedings. And when it goes back to standard proceedings, the ADP stip is basically void. But once they're in ADP, that stipulation controls from there on.
So if the attorney is unsuccessful in completing the terms of the ADP, then that attorney would be disciplined according to the high. Is that what happens?
That's correct.
I see. Okay. So if the attorney goes into ADP and doesn't reject it, then the stipulation is going to control what happens to the attorney, either high or low.
Correct. Yeah. Ideally, the judge's high-low offer is based on that stipulation. It's from the misconduct as reflected in the stipulation.
Okay. The other thing I was going to mention is if it would be helpful to the group to know how other diversion programs work within the Department of Consumer Affairs. They're a little bit different than this. And I can't speak to all of them, but for example, a lot of the healing arts agencies, such as the Board of Registered Nursing, Board of Pharmacy, Dental Board, they have diversion programs that are pretty much called diversion programs, and they deal with this sort of, basically substance abuse issues as opposed to mental health and substance abuse. But they deal with it on a pre-filing basis, so there is no public record against the respondent at the time the diversion takes place. And it's similar to the type of criminal diversion where there has not been a guilty plea or admission to charges. And in other words, pre-filing as opposed to post-filing. So a nurse, for example, may go through a diversion program for a period of time and ultimately fall out of diversion by not completing it successfully. And then at that point, an accusation would be filed against the nurse for whatever the underlying charges were to go through the disciplinary process. So I just wanted to inform the group about how things are done differently in other groups. Thank you.
Melanie, please.
I'm not sure I have my hand up, but I will just add to what Ellen mentioned. I did want to clarify on moral turpitude as a disqualifying factor. It's not just moral turpitude. It's moral turpitude where significant harm happens to a client or the administration of justice. So that is disqualifying. And also, I'm sorry, I may have missed this. I had to take a call, but my understanding of back when ADP began was that it was much more liberally used. I think that the criteria for getting in it was much looser. And our office's experience of that was, we had to have a full unit dedicated to ADP cases because there were so many people in it. And I think the feeling was that there were a lot of folks that were in it that really shouldn't have been in it. Thereafter, the rules were changed to really limit the number of people, not the number of people, but limit the criteria so that we were really focusing on the people that were appropriately in a program like this.
So Melanie, you raised an interesting point, and I remember the early days as well, and there were some abuses. I get it, but if we look at the big picture here, shouldn't we have more people in ADP? And I know that that's a really existential question, but the idea is that it's a good program, and there's a consistent and constant monitoring, not just from mental health professionals and drug and addiction specialists, but also from the court. And so in that regard, aren't we all winning? And shouldn't we be figuring out a way to widen the filter? Thoughts?
And Chair Lear, Karen Bell has had her hand up for a little bit. there. But I will echo Melanie. I worked in the lawyer assistance program for 5 years, and I was around when they changed the rules to add the moral turpitude with the client harm. And the program participants went from 500 down to almost less than 100 after those rule changes happened. And so it did significantly impact that. And I think it was like 2007 or 2008 when those rules went into effect. So I just wanted to add context, but Ms. Bell has had her hand up.
Thanks, Justin. I was curious, Ed, if you could speak a little bit more about when you were speaking initially, you were talking about this particular case that you had and where you had suggested maybe there could be some kind of a mini hearing on the question of moral turpitude. And I was just curious to hear more about what that would look like. And the reason I asked that is because I just worry that, you know, if the recommendation goes forward to change this, I wonder if there'll be pushback, if that would be something where, you know, the bar might say, well, we put this moral turpitude in for a reason, and, you know, we're not going to change it again. I just don't know if there's like a compromise there where maybe this mini trial could work. I don't know. I don't know what that would look like or if it is workable, but I was just curious because you mentioned that that was something you had suggested in your particular case.
Right, and we didn't get into the weeds on that, but here was the problem. Aaron, you teed it up really well, which is to say that the scheme to defraud allegations in that case basically would have meant that the mini trial would have been the whole trial. And so there was not really a way to carve it out and separate it out. So that on a certain level was a non-starter. And I was thinking about it really hard, like, how do we do this? This just doesn't seem right. But no resolution. And so my client now, when we entered into a stipulation, he doesn't have moral turpitude. That was really important to him. And Linda in particular can appreciate this. He was a dual license holder. So he also had a real estate broker's license and was making his money through the real estate brokerage. So what was tantamount to him in the negotiation was that we get rid of the moral turpitude because there was going to be a reciprocal discipline proceeding with the DRE. And so ultimately that worked out for him, but I still think he should have been in ADP. There's a point that Justin raised, and it goes back to somewhat my existential question, to which I'd like, or have all you address, is if I heard Justin right, in around 2007, 2008, we went from 500 lawyers in the ADP program down to around 100 once the moral turpitude disqualifier was added. And the existential question again is, well, wait a second, we had 500 in, this is a good program, then we went down to 100. That seems to me to be a really bad metric in the grand scheme. Comments?
Well, I just want to add, I want to be clear that I'm not certain that the rule changes in 2007, 2008 were just to add the disqualifying factor of moral turpitude with significant client harm. Let's be clear about that, and the administration of justice. So I think there likely were more changes to it. So I don't think that was the only limiting factor. But you know, I don't really know how to answer the question, Ed. Shouldn't it be more? I don't know if there are. I don't know how you would even study that, because I don't know that it's just a feeling that should be based on just a feeling. I can only say that, you know, and it might be of benefit to look back on why the changes were made and what the specific changes were. I can only say that from my recollection of the experience, it was a literal free-for-all. There is seemingly no criteria and everyone was getting into it. And I think that there is, you know, a use for it. I think there clearly are folks who suffer from these issues and that those issues cause the discipline, and where we can rectify those issues and get them on the right track, I think it's appropriate to do that. But just, you know, garden variety misconduct or misconduct that is harming the public, I'm not sure that that is appropriate for that kind of program.
Okay, and a little bit of pushback, and this is not necessarily my position, but just for the purpose of the colloquy. So when you get into ADP, it's not a freebie. you didn't get away with anything. You have to do 18 months to 3 years worth of weekly classes, not weekly classes, weekly counseling sessions. There are other requirements that you have to do. So you're not getting away with anything. And isn't that in its totality a good thing for everybody? Was that rhetorical?
Chair Ellen Pansky has her hand up.
Thank you. So I wanted to answer Karen's question a little more directly, and there's been some allusions to this, but the way it works is there has to be a petition filed to be transferred to ADP. The entire case then is abated. The discipline side case is abated, and the matter transfers over to a designated ADP judge. And there is a mini hearing process where that ADP judge has to determine whether there is a nexus, and that's the words that's used in the proceeding, between the either substance abuse or mental health issue and the alleged misconduct. So there is already a procedure to do a hearing. I don't think it would be tremendously difficult to just include in that existing procedure the second question, which is this or is this not a per se moral turpitude with client harm or significant harm case? And I don't see any reason why the same judge that's making the determination whether there's a nexus couldn't also make the determination at the same time whether there's a disqualifying moral turpitude allegation. And from my anecdotal experience, when that new rule came into place, it was in fact a situation where the respondents, although they fervently wanted and were willing to go into ADP and to do all of the many counseling and other requirements and by the way, the courts hold regular status conferences at which the respondent is required to appear. At that time, they have the report from the Lawyers Assistance Program that tells the judge if the lawyer is in compliance or not. They can be kicked out at that point. So I do think that it is not correct to say that it was a free-for-all and people got in it who shouldn't have. I'm sure there were some people who did, but for the most part, people are reluctant to go on record and say, I'm an alcoholic, I have a substance abuse problem, I have a mental health problem, if they don't. And there's a gatekeeper there, which is a judge. So it's my recommendation that the judge be permitted also to make the moral turpitude evaluation in the same proceeding where they make the nexus evaluation.
Justin, any other hands up?
No.
Okay. Does anybody else have any further comments on this topic?
And I think we'll circle back to the diversion and the ADP at the end, but Lisa has a presentation now on recidivism that we'd like to present and then kind of sum up the discussion after that.
Great.
Okay, great. Good morning, everyone. We have some data to share with regards to folks who participated in ADP or received an LAD. We're using the word recidivism very broadly here. In particular, we're analyzing two outcomes. One is whether or not folks received a subsequent complaint and whether or not an investigation was opened against them. And so we analyzed data among people who had probation between 2012, 2017. We looked at 4 categories of people who just had a regular probation, people who were sent to ADP, participating in ADP, people who received an agreement in lieu of discipline, and those who just received a reproval. The question is, what happened 1, 2, 3 years later? And again, we looked at whether another complaint was filed against them or whether an investigation was opened. And so this analysis here looks at who received a complaint. The first set of bars is for within 1 year, the next one is 2 years and 3 years. So if you look at this, it looks as though there is, if you look at the diversion programs we're looking at in particular, here's the ADP folks right here, and here's the folks that receives the ALD. There isn't a big difference between these groups 3 years out who received at least a new complaint. If you look at folks.
Lisa, can I interrupt you just to ask a clarifying question? So
Sure.
Received a new complaint from what starting point? From the end? So for example, with probation, at the end of their term of probation,
I think
or from the end of ADP, or beginning when the discipline was imposed?
when the discipline was imposed.
Okay, so it could include, so that the 1-year follow-up could include people who are still on probation and they get, they pick up a new complaint while they're still on probation.
Yes.
And same with ADP and, okay, thank you.
Following up on that, Lisa, does the new complaint, is there a requirement that the new complaint be from not just received, but from conduct that is following the placement on probation?
No, this is just any complaint.
So the conduct could
No, but the timing issue, and I understand from Ron that he feels that the data now, there are 2 different dates in the data. One relates to when the complaint is filed, the other relates to when the conduct was alleged to have occurred, and that he drives these analyses off of the date when the conduct was alleged to have occurred. So assuming that that data is reliable, and then this would be for new conduct, not for conduct prior to when the discipline was imposed.
This next analysis looks at whether a new investigation was opened. And so here, in this case, the ADP has a little bit of a bigger standout 3 years out. And so what this shows is that people who participated in ADP, 3 years later, 45% of them had a new investigation opened against them. So that's—
Since I started talking, I'm just going to continue, because I just want to note one thing about this. I mean, what strikes me as most noteworthy, and I think it's highlighted by that big circle, is, it's not the bars within that, it's really the comparison between the different programs, and it's clearly highlighted in your slide, but I just wanted to put I wanted to sort of put some extra emphasis on that. That one set of bars looks like the most different from the others.
Yes, thank you. Okay, so then we also did an analysis of a more recent cohort of people who received an ALD. There were 59 ALDs issued between 2016 and 2020. And again, we asked what happened 1, 2, 3 years out. And in this case, we also added a third outcome analyzed, and that is whether or not a new complaint was disciplined. And so what this shows is that, okay, so in this case, we're looking at, actually, I said 1, 2, 3 years out. We actually took a little finer tune look at it, whether it's 6 months out, 12 months out, 24 months out, or 36 months out. And so as you can see, 36 months later, 33% of people who had an ALD had a new complaint. But it really drops down into less than 20% for whether or not these new complaints resulted in an investigation, and even fewer among that resulted in an actual discipline 3 years out. It goes down to, so the way you interpret this is, 3 years later, 7% of people who had an ALD were disciplined. Okay.
Lisa, you might not be able to see this, but Melanie has her hand raised.
Go ahead, Melanie.
Yeah, sorry, I might have missed this, but so we're looking at ALDs now, but did you have data on those folks who were in ADP and who were subsequently disciplined? I saw complaints and investigations, but we don't know. We don't know because we don't know.
No, it's just that that analysis we did it a while ago, and we didn't, at the time, we didn't do that third outcome, which was discipline.
Okay, it seems like that would be helpful, especially if we're talking about, whether or not ADP should be opened up to more people.
Yes, yes. Okay, does anyone have any questions about this? Okay, great. Okay, thank you. Okay, Justin, up to you.
So this is where we kind of regroup. Well, it looks like Greg has his hand up. Greg, you're on mute. I don't.
There we go. Sorry about that. Just to build on what Melanie just requested, I think it would also be interesting, and I don't know if this data would be available, but to understand of those who completed ADP, enrolled and completed ADP, and were subsequently disciplined, comparing that to the population before the rule changes that we were talking about, when more people were being enrolled in ADP, just to get to, I think, what Edward was alluding to, whether or not this program was as effective then as it is now. I would be interested in knowing that.
Okay. So it sounds like there's been a lot of interest in this area. Because we don't have a quorum, we can't necessarily take volunteers and form a working group. But this is where I'm asking the subcommittee, is this an area of focus where we should develop a working group and take a look at the diversion and the ADP? And it sounds like there's going to be some data requests so people can make some informed decisions and research on when the rules were and what exactly changes took place prior. So I'm seeing nodding of heads. Unfortunately, we can't take any action right now because we don't have a quorum, but we can in September. And so I will be looking for volunteers in September for this working group. But my sense from the subcommittee is that this should be an area of focus that could potentially develop recommendations.
I think so, Justin. I have a question that's I suppose particularly directed to OCTC. With this assumption to my question, which is assuming no abuse of people trying to enter into ADP, and I know that that's a far-fetched assumption, but let's just say for the purposes of my question, is there any pushback from OCTC into broadening the filter for ADP? In other words, more numbers. We're at 100 now, approximately. I don't know if that's the right number, but is there any downside to going back up to 500?
Well, I think before we get there, we would want to know how effective it is. And I think that's, part of the data request. Because if we're just spinning our wheels and it's just, it's good for the respondent, but it's not good long-term for the public, then I'm not sure that it makes sense. I think the other things that we would have to think about, just as a practical matter for the office, are resource issues. Like I said before, we had to dedicate a whole unit to 3 attorneys full-time to ADP. That's what they did. And now if it's part of a longer term proactive effort and you're getting something for it in the long run, then that might be a good use of resources. But if you're not, then it doesn't necessarily make sense. I would be concerned also, in looking and talking about changing the criteria, I would be concerned about allowing people to participate in ADP who have significantly harmed the public. I don't think that that's good public protection in the end. Someone who has intentionally stolen thousands of dollars from the public, from a client, and not made restitution, I don't think that that's a person that should be in ADP, but that's my personal opinion. I also think, going back to just the idea of a subgroup, I would want us to look at, what the changes were and why they were made, rather than just reinventing the wheel.
All right, thank you for those comments. And is part of what you just said driven by the recidivism statistics that we were just looking at? Or is all of it driven by that?
I think that it is greatly driven by it. I don't know if it's entirely driven by it. The fact of someone harming a client, significantly harming a client and not making good, I don't think that's not based in recidivism statistics. I fundamentally don't think that person should participate in ADP. But in terms of looking at it more broadly, I think we would want to know how effective it is before we decide whether or not we should be expanding it.
I don't see the hands. Justin, anybody?
Ellen has her hand up.
I just wanted to point out, it's not exactly on point to ADP, and I do agree with Melanie that we need to see the statistics as to not just, how many complaints, because the vast majority of complaints are closed. That the fact that a lawyer gets a complaint against them is almost irrelevant. It's whether they end up with another disciplinary proceeding filed against them. But the analog is ethics school. And I'm not clear on whether staff is in the process of gathering the data as to the percentage of lawyers who go on to a new violation after having attended ethics school. I do know, again, anecdotally, that many years ago, the statistic was only 3%. And to me, the striking statistic here is that even after 36 months, the percentage of lawyers who had entered into an ALD, an agreement in lieu of discipline, constitutes only 7% of recidivists. That's a very powerful statistic. So I hope we can get more data on how lawyers who have been through educational programs as well as the ADP program either are or are not recidivists.
And Linda has her hand up.
Yeah, I agree with Ellen that complaints aren't a good measure of whether or not a program is successful, because anybody can make a complaint about anybody for any reason. It doesn't necessarily have any merit. A better point, as Ellen mentioned, would be to look at statistics from what, based upon whether or not another proceeding is pursued by the state bar. But also, if we're going to look at statistics on the effectiveness of the various programs that the state bar currently has, we should look at the statistics for each of the different programs. In other words, general discipline, as well as, excuse me, the warnings and the admonitions and the different vehicles that you use. So to be able to compare each of them, if recidivism is an important metric in terms of the effectiveness of the state bar's programs.
Justin, I know we don't have a quorum, or at least I'm assuming that, but I do like the idea of a working group on the expansion of ADP. Do I hear any pushback on that? I don't think so. So we won't make a decision on that because we can't, but let's at least pin that for the next meeting, so we can play that out a little bit. I think this has been a really interesting discussion on that, and we can explore through the further statistics and metrics as to whether expansion of ADP makes sense for all. Okay, good. Any other comments or questions?
Just a clarifying. Okay, go ahead, Sean.
Yeah, Sean has his hand.
Oh, hi, everyone. So I just want to clarify, Ed, so because I've been a little distracted, I apologize. So this working group, is it limited to ADP or to these diversionary programs in general?
Well, I haven't defined it that way, and let's talk about it. What do you all think?
Because I think it would be worth some further discussions about, I'm not so sure about admonitions, but agreements in lieu of discipline, because, Ed, you discussed them from the standpoint of the benefit to the lawyer. And of course, we need to look at it from both sides. I think it can be very beneficial to the operation of the system in general, because as you said, they are so motivational for the lawyer to comply. And it gives it, although it's Melanie is more obviously way more expert on allocation of resources within OCTC, but I'm sure that preparing those agreements is less work than taking a case, say, to trial. And my experience when I did do some defense work was there were definitely cases that could be resolved with an ALD where the lawyer would admit culpability, but wouldn't admit culpability in a regular public stipulation. It would take the case to trial. So in that sense, it conserves resources, and then the lawyer has admitted to a violation. So if he violates either the ALD or commits another disciplinary violation, then you've already got charges ready to go against him. So it might be worth discussing whether that mechanism is more useful, and also this moral turpitude issue, because what I was hearing from the defense side was I think taking Melanie's comments and the defense side comments together, that I thought Melanie's point was well taken, that for someone for whom has done something like what Melanie described, which is stealing a lot of money and not even attempting to replace it. I'm not sure replacing it is good enough if they've actually stolen a lot of money. But on the other hand, if there's a real serious evidentiary question as to whether the evidence will show moral turpitude, whether there's some in between way there. So that might also relate to the other discussions we're having about that issue. So sorry, I've held forth for too long, but I don't think we should limit the scope of this working group, and we ought to discuss all of those issues. The other thing I'd suggest, Ed, is you might go ahead and find out who's interested in being on this group, because I'm not 100% sure that we need a vote for people just to go and start working on a project, especially if, and we might want to consult with OGC about this, so that, and we may just need to schedule a very brief special meeting if we actually have to appoint these people, because I don't think we want to introduce so much delay by waiting to the next meeting of this group. So thanks for listening and patience.
All right, good points, Sean. And I do like your idea of widening the working group and calling it more the diversion working group rather than limited to should ADP be expanded or not. Because I think that through the presentations today, it's clear and obvious that other than ADP, there are other mechanisms that allow for non-disciplinary results, and further that not everyone qualifies for ADP, period. I mean, in fact, most don't qualify for ADP. So in that regard, I think that's a good idea. Why don't we, well, let me ask, who's interested in being on what we will call the diversion working group? Ellen, thank you. Steve. And so Ellen and Steve at this point. Okay, good, thank you. Is 2 enough for a working group? I think it is.
Well, yes, I mean, we can do 2 person working groups. And I checked with OGC before this meeting. That's where I got the direction that we shouldn't appoint anything here, but I'll go back with the question of, do we have to wait till the next time, or if there's some way that we can get this started beforehand?
And on this one, I'm really thinking out loud, but this is a working group where, oh no, I guess we would benefit by having a judge on it. And let me ask, I guess it would be Justin first. Would it be appropriate to have a working group member who's not on the commission? In other words, a judge who is not part of the commission, because everyone's getting spread a little thin. Comment? I don't know the rules.
I'm not experienced enough in the rules. I don't know if Dag or Lisa know. And we don't have OGC.
I don't think that would be allowed. I think it has to be someone of the full working group to make a subcommittee member. And the other thing I would say is that you probably want to have a subcommittee that is comprised of an odd number of members, to just break ties so that you can gain some consensus.
Okay, so that all points towards drafting Judge Wang. When you're not here is when you get put on the committees.
Karen has her hand up.
Karen. Can't hear you. You're on mute.
Yeah, I just wanted to offer, I sort of wanted to see who else might volunteer, because I think I have less relevant experience than others on the committee. And so, but if I'm needed to break the tie or lighten the load, I'm happy to help with I am interested in the topic. I just didn't know if I had as much to bring to the table as others. But if if I could help in some way, I would be willing to do that.
Okay, well, thank you. Ed, you're on mute.
thank you for volunteering. I think it'd be particularly valuable to have you on because you don't know the system as well as Steve and Ellen. And so I think you bring a fresh and interesting perspective and be really helpful. So thank you for volunteering. So let's see. Do we need to wait for the quorum or not wait for the quorum? I missed that. To form a working group.
My previous instruction from Suzanne Grant was that we can't form anything today.
Okay.
But I will go back and clarify that and see if isn't a way that we can get this started sooner than later.
Sure, and I have a follow-up question to that, which is, can we have a vote by email?
I don't believe so, because that would be, you have to notice any action and we wouldn't notice that, so.
Understood.
Yeah, that's correct. We can't do that.
Okay, got it. So then we'll just table that. Thank you. Any other comments, questions? No. Okay, Justin, what's next on our agenda?
It's a deep dive into the metrics. So Lisa will present all the metrics associated with the Office of Chief Trial Counsel.
Okay, and quick question before we begin that. So Lisa, approximately how long is your presentation?
Maybe like 10 minutes, 10 to 15 max. We should finish before lunch.
Okay, so why don't we do that and then we'll take a lunch break at noon. Great, thank you.
Okay, good morning, everyone. Still morning here. I'm here to give an overview of the metrics with a focus on the metrics that the State Bar currently tracks for OCTC. And in particular, I'm going to share the metrics that we report to the Board of Trustees on a regular basis. Then I'll also share about different data points that we present in the Discipline System Statistical Report. And I'll just explain how these two reports are different and why. I will also share what we don't track at this time. And the reason I'm going to do that is because really in the course of this ad hoc commission, we received a lot of data points and I'll go scrambling and I'll say, oh, we don't collect that. And so we've started to generate lists of data points that we could potentially add to our metrics reports and to the DSSR, and I'll be sharing that with you. And then finally, I'll conclude with our staff recommendation for the path forward with regards to this topic. So let's start with the metrics and what I mean by that. So in January 2019, the State Bar established metrics for all functional areas of the bar and the purpose was to illustrate impact, to identify areas of improvement, and celebrate successes. And it's really also for accountability purposes. And most metrics have targets to shoot for. And my office prepares a report that we give to the Board of Trustees 3 times a year. And OCTC has 10 metrics that we regularly report on, and 5 of these metrics have targets. My office also prepares what we call the DSSR, the Discipline System Statistical Report. In this report, you can see 13 months worth of data for all of those metrics on the discipline system. We also have additional data points that give context to the metrics. So for example, lots of metrics are reported at the percentage level, percent of whatever. Whereas you can go to the DSSR and see the number of cases, for example, that underlie that particular metric. And this report also has data on recidivism as well as analysis that we've done on our complaining witness surveys. And so now what I'm going to do is I'm going to go through the different data that we track organized by different topics. So for example, one big topic is the OCTC case inventory. And what we report across the metrics report and the DSSR is overall inventory. We also report overall inventory by the different case closure stages. So for example, how many cases were closed in intake, how many cases were closed in investigation, and what the inventory looks like by the case prioritization status. What we don't report is the inventory by case type. So for example, how many cases in inventory are original matters versus RA bank matters versus criminal convictions. And here's an example of a chart that we produced for the DSSR. So this is the total OCTC inventory by stage. And as you can see, we always try to show 13 months of data, so the audience can say, look at the most recent month, May 20, for May, and then on the far left will be what the inventory was for the same month a year ago. We also have metrics and data points with regards to case cycle. What we report are things like how long it takes, the median case time for a case to be disposed, and what the 90th percentile disposition time is for cases that are reported in the ADR. And what I mean by that is that statute requires us to report out on the backlog of complaints, state bar initiated inquiries, probation referrals, and reportable actions. And so in our reporting, we limit our disposition time reporting to those 4 types of cases. We also report out on the median disposition time for P2 cases. And then we also report out on the percent of P2 cases that are resolved in 120 days. And then we also report on the annual caseload clearance rate. What we don't report is these disposition times for all cases. Like I said, we just limit our reporting to those that we report in the annual discipline report. And we also don't report any kind of disaggregation by closure stage, like how long it took for cases that were closed at intake, how long did it take? Cases closed at investigation, how long did it take? And we also don't do it by case type. Like I said, those case types are things like original matters versus reportable actions. And we also don't report out on internal benchmarks for case processing that OCTC has established for itself. And that is that they've established for themselves that once all evidence is in, the goal is to process cases within 30 days for P1 cases and 45 days for P2 cases. This was a recent criticism that we received in the most recent audit. And OCTC is working towards doing what it needs to do in order to start tracking this data with regards to establishing these metrics and being able to report out on them. So here's an example of some reporting that we've done on this. So the left would be the case disposition times. And so the teal bar is the median for all cases closed. Again, for cases that were we only report in the ADR, this is the median time for closing a case. And the blue bar is the 90th percentile. So like so that means like all cases that were 90% of all cases were closed within 401 days. That's at the highest level. So, and on the right, here's an example of what we report on the annual caseload clearance rate. Okay, so we also report out on backlog. And as a reminder, backlog is defined in statute as cases that are in inventory for more than 180 days. What we report, and by statute, all backlog, it's limited to these, what we call ADR cases. Again, those 4 types of cases. We also report out on how many cases are in backlog according to different priority statuses. We report out on cases that are in backlog that are in active status versus suspended status. We also share what percent of backlog that are P1 cases. And then we also, this is a new metric, but we also report out on the number of respondents with active license in a P1 cases, because our opinion is that this is actually the group that is most, at risk to the public. Respondents with an active license who have a P1 case against that's open. But what we don't report is whether or not, the backlog that's disaggregated by the case type, again, whether it's an original matter versus an RA bank matter, et cetera. And here's an example of a chart that we produce on a regular basis in the DSSR. This shows the backlog total, and it also, so that's on the left for each month. This is the number of cases that were in backlog at the end of the month. And then the middle bars is the priority cases, priority 1 cases that were in backlog, and the last set of bars are priority 2 cases in backlog. Here's an example of the most recent metric we developed with regards to respondents. And what this shows is that this is the number of attorneys, respondents that have it, that are in backlog, and they have an backlog. And it's a P1 case that's in backlog, and they also have an active license. We also do metrics with regards to the quality of OCTC. And what we report are the percent of Walker petitions that are denied, percent of complaint review units cases that are reopened for reasons other than new evidence, and the percent of random audit cases reopened for substantive reasons. So let me just say something about the, because I don't think we've ever talked about this random audit. So we do, we have an external auditor who comes and audits OCTC cases that were closed on a 6 months basis, and then they make recommendations for considering a reopening for a substantial reason. They'll review the case files and make a recommendation. And so we report out on the percent of those random audit cases that were reopened. What we don't report, though, is the percent of those random audit cases that the auditor recommends to be reopened. So for example, what we do report is how, so OCTC receives the recommendations from this auditor, and then they look at the recommendations and they make a decision whether or not to reopen it. We don't report what the auditor initially recommended. So here's an example of the Walker petitions. So the Walker petitions are petitions of the Supreme Court that say this, my case with, I'm sorry, I'm totally blanking on Walker petitions. Steve, can you help me out with this, please, or Melanie, what the Walker petition is?
It's when after a case goes through the complaint review unit, if they determine to keep it closed, the complaining witness can file a petition with the California Supreme Court requesting reopen.
Okay, thank you. Thank you for that. So we track this this data. Around 100 petitions go to the Supreme Court every year, and the baseline for OCTC is that back in 2018, 99% of those petitions were denied. And so the goal is that to always keep it at 99% or higher, obviously a huge bar. And so as you can see, for the last 2 years, they've met that goal for the 2 years. This chart here on the left shows the percent of the complaint review units reopens for reasons other than new evidence. The baseline was 2%, so that means that only 2% of the complaint review unit cases were reopened. And so ever since then, in the most recent data available, they've kept it at 2%. Okay, so fairness is actually a new set of metrics for OCTC. And really this is driven by our work from Professor Robertson, the Farkas report. So the metric we have is the percent of respondents that have representation during investigation and beyond. Here on the right is our most recent reporting for that metric. What we don't report, though, is this data by race, ethnicity, and gender. As you recall from the Farkas report, what really drove this metric and the development of it is the fact that African-American men were less likely to have representation in investigation and in disciplinary proceedings than white men. And so that's something that we don't do, is we just report it at the total respondent level rather than disaggregated by race, ethnicity, and gender. And then finally, recidivism. We report the percent of respondents that receive a complaint, investigation, or a discipline. And we look at this by a variety of outcomes, whether there's someone who received a reproval, probation, and here's an example of the probation data that we report on a regular basis. So what this shows is that what happens to people who receive probation within 2 years. The blue bar on the left is the new complaint received, and the lightest bar is the new discipline imposed. And what this shows is that for this data is for each year. So it starts, so for all the people that received probation in 2015, this is what happened to them 2 years later. What our recidivism analysis doesn't show is, one, whether or not the recidivism occurs outside of the probation period. We just look at whether it just happened or not. And we also don't analyze misconduct in particular. So for example, we don't analyze when someone experiences a new complaint or the investigation or whatever it is, we don't compare what the misconduct allegation is or misconduct discipline was, how that compares to what they were originally disciplined for. And so we don't, so for example, so data, the research questions that could be generated from this are like, do respondents experience the same misconduct when they come back into the system, whether it's a complaint or discipline, or is it even escalating misconduct? So we don't report that. And then also in the process,
Lisa?
Sure.
I was really interested in this one, looking at 2019 and looking at the lightest blue on the far right,
yes,
where new discipline imposed was pretty significantly lower than the other years, despite the fact that the dark blue new complaint received was pretty high. What did you drill down at all as to what happened there? That's interesting.
Well, the thing about 2019 is that 2 years out, we're not done yet with the entire year of 2021. You see that? I think, yeah. So
Okay,
yeah,
I understand.
Yeah.
I understand.
yeah. So maybe once the year closes out, that lighter bar may change. Okay, so here now in general, here's other topics that we don't regularly report out on. We don't report out on settlement rates. This information is actually in the ADR, which we report out once a year, but it's not part of our regular reporting to the Board of Trustees. We don't report out on the number of ENECs that are held. And we don't do reporting on misconduct allegations. So for example, percent of complaints coming in, how many of them are performance versus misappropriation versus communication, et cetera. And we also don't do regular reporting on the type of misconduct that is disciplined. So for example, what percent of all cases that are disciplined are done for moral turpitude versus performance versus misappropriation, et cetera.
Sorry to interrupt again.
Okay.
I'm on the ENEC working group, and so I note that you're not reporting on the number of ENECs held. So do we have any metric to figure out the success rate of ENECs? I think I'm answering my own question. If you're not reporting on the number of ENECs held, then probably not, don't have a statistic on how successful or not ENECs are.
Right, we probably will be able to get that data. What I'm saying is that we don't regularly report out on it.
I see, okay.
Okay, all right. So given everything that I've shared with you, one option is for you all to form a working group to give us new ideas. For example, look at all the lists that I just shared of the non-reporting and say, yes, so you guys should start reporting this. But we'd like to propose an alternative path forward. And that is, rather than creating a working group, we suggest that one potential recommendation moving forward, like down the road, will be that the State Bar should review all current reporting in the light of Ad Hoc Commission's discussions or recommendations and adopt additional metrics as needed. Because staff is paying attention to all the data requests and conversations and kind of saying, oh yeah, we don't have that data. We don't report that data. It's not at my fingertips to show someone. And we are committed to reviewing everything and improving our reporting. And so rather than a working group trying to figure this out as all this other work is going on through the working groups, we recommend that the group consider adopting a recommendation like this at the end, and of course holding us accountable. We'll be held accountable. Our Board of Trustees will hold us accountable to this. Okay. Does anyone have any questions or comments about our recommended path forward with regards to metrics?
Yes, I do.
Sure.
Can you put that screen back up?
Oh, okay. Okay, I'm not suggesting adopting this language. I'm giving you an example, but let me just share my screen.
Yeah, but my comment is that the language is awfully broad in recommendation. I know that must have been intentional, but so because it's so broad, I'm not sure what it means. Okay. And so in that regard, the Ad Hoc Commission is clearly having discussions, and is the intent of this to essentially review current reporting as directed by the Ad Hoc Commission's recommendations? So in other words, I'll just give the ENEC example. So where I see that there's no reporting regarding number of ENECs, then it is the idea that we as a group would either decide that we want to know how many ENECs have occurred, or we as a group would decide that we don't care. And then your group would follow through based on that recommendation. Is that the way you see it?
That's definitely one way that can happen, because of course, like if you're the working group wants to write that into their recommendation as part of a broader recommendation with regards to ENECs, then that absolutely would occur. But what I'm saying is that I think that we would probably do that in any case, because we've seen that like people have asked for ENECs and, oh yes, we don't report on this, and we would strongly consider adding this to our regular reporting, because we've seen that it's been of interest to lots of stakeholders.
Right, and I'm sure that Ellen, there she is raising her hand.
And Sean had his hand up first, and then Ellen.
Oh, okay, go ahead. Yes, thank you.
Hi. So I would say my suggestion, Lisa and Ed, would be, Lisa, I think you're right. I think the commission members here are just pulled in many different directions. We have a lot going on. So I think you're right. Maybe a working group isn't the right story, but I'm a little right approach, but I'm concerned that this recommendation is sort of just caps off this discussion at the commission completely. So what I think we ought to do is kind of keep this on the list of things for the commission to give feedback on, and then bring it back to us later in the process when we have recommendations starting to develop, perhaps in draft form, because the group might have some view on which things should be tracked that aren't currently tracked. And then we can decide then whether to put more effort into it.
Ellen.
Thank you. Along the lines that Sean just mentioned, we already have two working groups. We have a moral turpitude working group and an ENEC working group. It seems to me that some of this could be incorporated into the agenda for probably both of those two groups. And I'd just like to say, to me, the meaningful statistic is not how many ENECs are held. The statistic is how many cases were resolved at or shortly after the ENEC, and again, tying into the other two groups, how many of the respondents in an ENEC were unrepresented? And I think the implicit assumption would be that if they had an ENEC with the assistance of a state bar court judge, the result ended up being acceptable to them. And the other statistic, again, now doing the crossover to the moral turpitude subcommittee, is how many cases, let me just divert for a second. So just for everybody's edification, when you go to an early neutral evaluation conference, both sides present briefs, and OCTC in almost every single time submits a draft notice of disciplinary charges. And so it would be a simple matter to assign somebody just to go through, even manually, say the last 2 years or 3 years, compare what was alleged in the draft NDC that was presented to the ENEC judge as compared to what ended up either in a stipulation or in a decision after trial. And I think that those are the meaningful statistics, because those will help us analyze how effective the ENEC process actually is, both in moving the cases through the system and in fairness.
Thank you. Any other questions or comments?
Looks like Linda has her hand up.
Just in responding to Ellen's comment about that, I think it would be extremely difficult to do that, to go through all the different documents and analyze the before and the after. That kind of work, I think it would be extremely difficult to do that. But I think it would be really helpful in considering metrics, what the state bar staff has to say and what they think would be helpful to look at in terms of processing their own work. Because the state bar staff knows better than anybody, how the caseload is being processed and what the pinch points are. So if whatever comes of this idea about reviewing metrics and reporting, that input from the for our staff would be most important. Secondly, I just wanted to mention that not everything needs to be reported that you can obtain from statistics. There are a lot of things that are of interest to this commission to learn about, to evaluate the effectiveness of the commission's disciplinary system and try to make it better if we can, but not everything necessarily needs to be reported, quote unquote. So just that comment.
Great, thank you. Justin, any other hands up?
I do not see any other hands up.
Okay, so question for Justin. About how much more time do we have in presentations after lunch?
The only thing we have after lunch is the kind of the summary and the wrap up and the next steps. So I'd say probably 30 to 45 minutes is what we have left.
Okay, so unless I see anybody with other comments, why don't we take a break until 12:30 with the idea that we will go till approximately 1:15-ish thereafter. So any other comments? No. Have a good lunch. See you at 12:30. Thanks.
Yep.
Thank you. We are back on the record, and Justin, can you take roll, I guess.
I don't see Melanie. Hopefully.
What's your head count for the purposes of the quorum?
I need all 8, and so I need Melanie to come back. And I wasn't. She's in. I think she has leadership. Let me.
Is in another meeting.
Whoops. Well, let's continue. And if she, Steve, how long is her meeting?
I don't know. I know she intends to return, but I don't know whether it will be a matter of minutes or half hour.
Okay, thank you. Justin, let's play it by ear. So once Melanie jumps back in, then we can interrupt the presentation. We can do a vote for purposes of creating the new working group, and then that'll be on the books, and then we can continue with the presentation. So with that, why don't we commence the presentation?
Let me check with Alexia, because I just had her come on for a brief minute, so I don't know how long she has. Alexia, do you know, can you stay with us for a minute, or do you have to go?
That's fine. I'll just, if it's okay, I'll leave you on in the background and I'll watch later the recording, but I could probably stay for the next hour, 45 minutes or so.
Okay.
Thanks.
All right. Thank you.
And Justin, if actually, maybe someone could ask Melanie just to take a brief break from her meeting so we can just get the votes on these 2 resolutions. Or
Sean,
one. I can't remember how many we have.
I only remembered 1. What do you know that I don't know? I was going to take your comment and incorporate it into the subgroup that we talked about for ADP and just create a working group for purposes of diversion, including ADP, ALD, warning letters, all of those other mechanisms. Did anybody understand it any differently than that?
Yeah, that's what I took away from it.
Okay, so that'll be one working group that we will be voting on.
Yes.
Okay, so with that, why don't we start the afternoon presentation?
Sounds good. Lisa, if you could share. So the final agenda item for today is to just talk about all the work that we've done and summarize the different topics that we've covered, and to make sure that we have agreement from the subcommittee on all the different topics that need working groups and follow up on. And so this is just to kind of complete the loop after all of the meetings that we've had. And so I will begin. If we could go to the next slide. So at first we brought the California state audit back to the commission, and we brought it twice, really. We kind of gave the findings of the audit, and then we brought it back to focus on the backlog statistic. Dag McLeod gave a presentation on that and possible alternatives to the backlog. And so the purpose was to review the findings from the most recent audit. Oh, it looks like Melanie is back. So if we want to take the roll really quick.
Yes.
Bell?
Yes, here.
Here. Duran, Farwell, Jones, Lawrence?
Here.
Mayorga?
Here.
Moab?
Here.
Nakau, Pansky?
Here.
Rosenblatt, Schneider,
Here.
Selig,
Here.
Stallings, Judge Wang, and Chair Lear. We have a quorum. So do we want to talk about the working group for diversion?
Yes, so I'm making a motion to create a working group for diversion, and that working group will explore how to make more effective use of ADP, ALDs, warning letters, and the like. And that's it. Do I hear a second?
Second.
Okay, all in favor? Aye.
I
Aye.
think it's remote. I have to call the roll, unfortunately. So Bell,
Aye.
Jones Farwell, Lawrence,
Well, I guess I have a question, because what I heard was that the purpose was to make more effective use. And I guess what I'm wondering is, I mean, with regard to the ADP, I don't know that we know if it is effective or not effective. I think that was part of the problem that we were talking about earlier. So I'm fine with taking a look at these, but I don't know if it should be with an eye towards making it more effective. I don't know if it's effective or not effective at this point.
Fair comment. I will amend to say to explore the effectiveness of ADP, ALDs, and the like. Is that satisfactory?
That's better.
Okay, so let me restate the whole thing just to clarify for the record. I make a motion to form a working group, the purpose of which will be to explore the effectiveness of diversionary measures like ADP, ALD, warning letters, and the like. Do I hear a
Accept
second?
the amendment.
Okay, so I've heard a second. And then now we, Mr. Ewert, can we please have a vote?
sure. Bell,
Aye.
Lawrence,
Aye.
Mayorga,
Aye.
Moab, Steve, sorry.
Yes.
Pansky,
Aye.
Schneider,
Yes.
Selig,
Yes.
the motion passes. Okay, thank you very much for rejoining us, Melanie and Alexia.
Justin, do we-
Excuse me, Mr. Chairman, I have to excuse myself for a few minutes. I'll be back in a little bit, okay? Something has just come up.
Thank you. Justin, with respect to the appointment of the members of the working group, do we need to put that to a vote, or does that just happen?
We can, I noted down that the working group members are Ellen and Steve and Karen. So we don't need to take that to a vote.
Thank you. Done. Let's go back to the presentation.
So we reviewed the California state audit just on the findings and the recommendations and alternatives to the backlogs that are currently being explored. And so the follow-up to this, the next steps is that there wasn't any recommendations that came from those discussions we presented to the subcommittee, and they did not find anything to further follow up on. But what staff is recommending is that as the recommendations to the 2020 state audit are implemented, we would bring that back to the full ad hoc commission so they could monitor that progress. But there wasn't necessarily a need for a working group related to the California state audit. And so that's where I'm turning to the committee, the subcommittee, to make sure that that finding is universally accepted. And hearing no objection, silence, I will say, we'll move forward then. So we also looked at case processing. And so we were reviewing the standardization in the charging and settling of cases. We had presentations by OCTC on what they do for calibration and how they do standardization. ADDC, Ed and Ellen gave their perspective. We also had Judge Wang give her perspective on the process. And Judge Wang also talked about the constraints associated with the progressive discipline. And so progressive discipline is something that has been talked about in the effectiveness subcommittee and also in the fairness subcommittee. There's been quite a lot of discussion on that. And so the recommendation here is, there are lots of recommendations here. Staff, this has to do with the calibration and some of the findings from the state audit that, Lisa, can you better explain this one?
So the auditor recommended that the state bar conduct a very comprehensive evaluation of OCTC's, the reorganization that occurred in OCTC for the purpose of understanding what parts of the reorganization may be contributing to the increasing time it takes us for cases to be resolved. And so we're committed to that evaluation. And so we recommend that, and case calibration, obviously, because it was part of the reorg, will be part of that evaluation. And I believe this evaluation is due to the auditor next June. I think with the preliminary report by January. I might be confusing that with another recommendation or compliance matter, but what is we recommend that the staff recommends that rather than forming a working group to take a deeper dive into case calibration, that you just know that we will be doing our own evaluation and you just again monitor this. We can be sharing out on our findings to this ad hoc commission as we conduct work.
As part of the implementation of the audit findings, bringing it back to the full commission. And then what the other?
Yeah, okay, and then the last piece is.
Right, and so this is where I would like some discussion or agreement that there should be a working group to review progressive discipline and prior discipline. Like I said, that the effectiveness and fairness subcommittees have both taken up this issue. And I think this is a working group that should be represented by both the members of the effectiveness and fairness. And I know some of you have two hats and sit on both committees and appreciate that. But I think at the September meeting, unless there's objection, we should ask for volunteers of the full ad hoc commission to form a working group that examines prior discipline, progressive discipline.
I think that's a good idea, and I think it would be good if at least one member on that working group committee would be from this part of from the effectiveness team. But we don't need to, unless there's a volunteer right now, we don't need to deal with that right now.
Yeah, I don't need volunteers now, but the direction is to form a working group. And so that will be brought up at the September meeting. If we can go to the next slide.
So, sorry, do we have confirmation that with regards to staff recommending that the calibration piece and case processing piece will be taken care of by the State Bar's work in response to the audit? Sounds like it. Okay. Okay. All right, we'll move on.
So the next area we covered was factors impacting case settlement. And we wanted to review the case settlement process and determine if changes were needed to increase settlement or if there should be an increased settlement. And so we provided the committee with a lot of information on ENECs. We had discussions on moral turpitude. We had different perspectives from State Bar Court, from OCTC, and from ADDC. And so the end result of the factors impacting case settlement was the creation of 2 working groups. We created the working group on ENEC, which is scheduled to meet for the first time on Monday. And then we also created the working group on moral turpitude, which is scheduled to meet next Thursday. And so these working groups will the first meeting will be agenda setting, define the goals and objectives of the working group and where there is data requests and other things. So this item, I think that we've done what we need to do with the factors impacting case settlement. We've created the 2 working groups, so I don't know that there's anything else to do with this, but just informing the subcommittee of the work they've done. Are there any questions or anything? Seeing none, we can go to the next slide.
Sorry, Justin, I have a question. I thought I was on the ENEC working group, but I didn't know there was a meeting on Monday. Am I mistaken?
I didn't know either.
I didn't catch that you were on that working group. My mistake. I can add you to the working.
I would like to be on the committee or on the working group.
Okay, I had that it was Chair Lear, Melanie, and Judge Wang. I can add you to that.
I appreciate it. Thank you.
Okay. Just writing a note. Okay. So without any other questions, we can go to the next slide. So we talked about prevention, support, resources, and mandated training for attorneys. We wanted to go over all the different things that State Bar does for attorneys, the Office of Professional Competence, and provides a lot of resources to attorneys. We heard from them with an emphasis on solo practitioners, that they have the ethics hotline, they have other resources, they have different guides that they provide. They also, Randy DeFentorum gave a presentation on the self-assessment program that was presented to the Board of Trustees that is going to be offered to attorneys where they can do self-assessments, and it's going to be limited at first, but hoping to expand to many self-assessment programs. And then the lawyer assistance program presented the resources that are available for attorneys with substance abuse or mental health issues, but they also do some career counseling and individual counseling in general for attorneys. And so these were the areas that were presented to the subcommittee. There wasn't, after the presentation from the Office of Professional Competence and the lawyer assistance program, there wasn't necessarily a discussion about follow-up. And so we have a lot of areas that we were following up, and we have a lot of working groups that we're creating, but I didn't get a sense from the subcommittee that this was an area where there necessarily was focus, but I am opening it up, the discussion, to the subcommittee to see if this is an area where they want to focus, or if this is an area where they're satisfied or want to just monitor maybe the implementation of the self-assessment programs. Ellen.
see this as an adjunct to some of the other issues that we've been discussing, including the diversion program and the ENEC program. I don't know whether, again, these issues can be combined and subsumed within the working groups that we already have. But part of this, again, I think is driven by the data. If the data is that, which seems to be the case, you know, a lawyer who has participated in an agreement in lieu of discipline will have necessarily gone to ethics school. And so since the recidivism rate seems to be relatively low, I would think that we would want to not disregard the impact of self-assessment and training and resources and so forth. So I'm not suggesting that it needs a separate group, but I would not want to see this resource lost.
Correct, and I think you are correct that it will be discussed in the other working groups, and that you know, the ethics school data and stuff like that will be a part of those other discussions. So I don't know that it necessarily needs a separate working group. I would agree. Karen.
You just reminded me, Justin, when we spoke about kind of aging and cognitive decline, was that as part of this discussion? Was there a different piece on that coming up? I just can't remember the order of events.
Yeah, I believe Randy referenced some resources that they have for attorneys that are closing their practices. And I believe that there was also, off the top of my head, I think it was in context with the stuff that the Office of Professional Competence presented on in terms of those resources.
I just felt like that was the only thing that I recall from the discussion where there was sort of a concern of, you know, is there more we could be doing? But I don't know that we necessarily said there needed to be a working group on that or anything like that. But I felt like there was interest and concern that maybe there was an area there where we should put some amount of focus. Maybe it falls into one of the other groups that we're already doing, or maybe it just doesn't rise to the level of you know, wanting to put the resources around it. I'm not sure, but just a question for the group, I guess.
I would echo, I guess I should raise my hand.
Go ahead, Steve.
I would echo what Karen said. I think that that part of the discussion centered around a retiring with dignity type of discussion, and essentially, you know, allowing people to step away from the practice of law on a permanent basis. And we had talked, I believe, sometimes it's hard, sometimes these conversations sort of meld together in my head, but I think we had talked about that is an option in several other jurisdictions, and something that we had, that I had been interested in looking into starting several years ago here. I'm not suggesting we need a working group or anything, but I agree that it is something that the bar in and of itself, or part of this commission, should continue to explore.
Okay, I will take back that feedback, and it's possible that we are going to have a couple of full ad hoc commission meetings, and so when we vet these other recommendations, this is an area where we can just bring back things, and upon exploration, if it determined that, oh no, we do need some feedback from the members and maybe need a one-time working group meeting or a separate meeting, then I will reach out for that. But I'm taking this area and taking notes, and so it will be brought back to the commission. Okay, we can go to the next slide. Discipline system metrics. I'm not going to spend a lot of time on this because we talked about it just today, but we're just covering all the topics. Lisa gave her presentation today. We were reviewing all the metrics that the State Bar collects, and whether or not there might be additional metrics needed. You can kind of just go through. We talked about this and how we're going to monitor this going forward and bring it back for full review to the full commission. So I don't think since we discussed this an hour ago, I don't know that we need to discuss it now. And then diversion is also from today. We talked about it. We've created a working group on diversion as a whole, and it sounds like we have a lot of research and data gathering that we need to do to come up with the appropriateness of looking at, or not the appropriateness of looking at, but actually looking at the programs that we currently use at the bar and see their effectiveness, and then whether or not there should be expansion or if there should be other things that are added to what we currently do. So I think since we created a working group, there's not much more to do on this topic. And that is the end of my presentation. So are there any lingering questions from the subcommittee from today's presentation or from prior presentations that they would like to ask?
Not on that, but Justin, how do you foresee the September meeting playing out? So we'll have the whole group of us together. What are we hoping to accomplish in that bigger group setting that we are not accomplishing in the smaller group setting?
So in the bigger group setting, because I've had feedback from the different committees, they don't always know what the other side is doing. And so there have been committee members that have expressed they'd like to know what the other side is doing. So the idea for the September meeting is for each side to present on all the work and the findings that they have so far, the working groups that they have initiated, and then also probably come up with possibly 1 or 2, 3 more working groups that are collaborative between the two subcommittees, and basically update the other side on what the other side has been doing for the past bit. And then once we have that full ad hoc commission meeting, then the working groups are going to do their work and really dig down into the details, get into the weeds of things. And then it's anticipated that we will bring back the recommendations from those several working groups to the full commission in a series of meetings where they can be fully vetted on the progress that they made and the recommendations they came up with and why they came up with those recommendations. And that discussion can happen at the full ad hoc commission.
Okay, thank you. Anybody else have any comments, questions, anything? Are there any hands up, Justin?
No, there are no hands up.
Okay, so as far as I know, that concludes our business for the day. Am I right?
That is correct.
Okay, good. Thank you, everybody. Thank you for the presentations, very informative. And I love the colloquy. That was great. I think we're really moving the ball along. And I'm just anxious as all get out to the point where we are making concrete recommendations. And I understand this background is all needed, but I do look forward to it. And I think that we are going to change the world. So thank you, everybody, and have a great weekend. Talk soon. Bye.